Generally, in products liability law, a drug manufacturer has a duty to warn others of the dangers involved in a drug's use. But what if a drug manufacturer warns a patient's doctor of a drug's dangers instead of the patient? Does this absolve the manufacturer of liability? In State ex rel Johnson & Johnson Corporation versus Carl, the West Virginia Supreme Court of Appeals considered this question in a case involving Propulsid, a nighttime heartburn drug. In May of 1999, Nancy Gellner was prescribed the drug Propulsid by her primary care physician, Daniel Wilson. The drug was manufactured and distributed by Janssen Pharmaceutica, a wholly owned subsidiary of Johnson & Johnson. Tragically, however, Gellner died 3 days after she started taking the drug. Subsequently, in May of 2001, Gellner's estate brought a products liability and medical malpractice action against Janssen and Wilson in State Circuit Court. In the action, Janssen moved for summary judgment, arguing that under the learned intermediary doctrine, it had fulfilled its duty to warn by providing warnings regarding the drug to Wilson. Specifically, Janssen argued that under this doctrine, because it had warned the prescribing physician of the risks associated with the drug, it didn't have a duty to warn consumers of the product's risks. The court denied the motion on the ground that questions of fact remained in dispute. Following the denial, Janssen filed a motion in limine to prevent the estate from presenting evidence that Janssen had a duty to provide any warnings regarding the drug to Gellner personally. The court, by order of Justice Mark Carl, denied the motion, concluding that West Virginia hasn't adopted the learned intermediary doctrine. Janssen then filed a writ of prohibition with the West Virginia Supreme Court of Appeals, seeking to prohibit enforcement of the court's order.